Hello, my name is Neil Carney. I'm a wealth manager at Franklyn Financial Management. I'm here today with Paul Tyrer, a partner in the corporate department at SAS Daniels, and we're going to be answering some questions about shareholder protection. Shareholder protection allows the remaining partners, shareholding directors or members to remain in control of the business following the death of a business owner. It is facilitated through life insurance, a cross-option agreement, business trust and critical illness cover. The loss or incapacity of a shareholder can disrupt a company, but by having shareholder protection in place, the interruption to your business will be minimised by enabling business continuity, funds being available to the individuals who wish to buy the shares, an improved tax position on the death of a shareholder, the deceased estate receiving funds in a timely manner, and the creation of a market for private company shares. It could take months or even years to conclude a sale to a third party. Alternatively, the spouse of the deceased may decide to retain the shares, and if he or she has no knowledge or understanding of the company, this could adversely affect the running of the company. Valuing an unquoted company is a difficult and complex task and should involve key professionals, principally the company accountants, and they can determine the most appropriate valuation method. Common methods include a multiple of the maintainable profits, the dividend yield, and the net assets of the company. With regards to the life insurance policies, it is really important that the trust is in place before the policy is on risk. The diagram highlights the process of the life plans being put into the business trust. Each life policy is written on the life of the shareholder for the benefit of the other shareholders in a business trust. On death, the policy proceeds are paid into the trust with the other shareholders being the beneficiaries. These funds are then used to purchase the shares from the deceased's estate.
It is prudent for shareholders to consider what happens to their shares, not only on death but during their lifetimes. A well-drafted and implemented shareholders agreement can ensure that the shares remain with the original owners if one shareholder wishes to dispose of his or her shares, leaves employment, or suffers a physical or mental incapacity. It can also deal with other key decisions, such as what happens when a third-party offer is made for the business and not all shareholders agree on the terms of the sale, so-called drag and tag rights, voting and decision-making, dividend policy, and confidentiality and non-compete clauses. A shareholder agreement confirms who will receive the deceased shares on death and how they will be valued. It is in a way the will for the business. Without this agreement in place, disputes could arise over the valuation of the shares, and the transactions regarding the payment of contributions could potentially be liable to income or capital gains tax. It is usually the case that the shareholders' agreement will contain a cross-option. A cross-option gives the surviving shareholders the option to buy the shares of the deceased individual from their executors or personal representatives. Correspondingly, the personal representatives of the deceased also have the option to require the remaining shareholders to purchase the shares if they elect to sell. If either side wishes to exercise their option, the other party must comply. Options can only be exercised on death, and there will be a specific option period, usually of around 2 to 3 months. A cross-option agreement does not jeopardise IHT business relief, formerly known as business property relief, and since there is no binding agreement to sell shares at the date of death, business property relief is preserved. All the shareholders involved in the shareholder protection arrangement should execute wills that dovetail with the cross-option agreement and to ensure their intended beneficiaries receive the proceeds free of any intestacy delays. Those involved should also bear in mind that their shares typically qualify for 100% business relief for IHT purposes.